A caregiver is supposed to be the safest person in the room, the one who checks the pulse, who measures the medication, who sits up at night so someone else does not have to. Families hand over their most fragile members to these people because the alternative, doing it alone, feels impossible. For the people in these cases, that trust became the exact thing that killed them. Some were infants left in a crib with a nurse who had learned to make death look like illness. Some were elderly patients hooked to an IV line that was supposed to save them. Some were children left in the care of a woman hired to keep them safe for an afternoon. Today we are covering 10 caregivers who became killers and the quiet, terrible gap between the job they were trusted to do and the harm they chose instead. Section 1. Janine Jones. In the late summer of 1981, inside the pediatric intensive care unit at Bexar County Hospital in San Antonio, Texas, the nurses on the night shift had already started calling their own unit something else. They called it the death shift, a grim joke passed quietly between co-workers who had noticed that a disproportionate number of children seemed to crash, suddenly and without warning, whenever one particular nurse was working. That nurse was Janine Jones, and by the time anyone outside that unit took the nickname seriously, more than 2 years had passed, and an unknown number of children, some put the figure as high as 60, had gone into cardiac arrest on her watch. She would eventually be convicted of killing only one of them in court, a 15-month-old girl named Chelsea McClellan, but the full scope of what happened inside that hospital, and later inside a small-town pediatric clinic, would take more than 3 decades to even begin to surface. Janine Ann Jones was born in 1950 and grew up in San Antonio. Public records about her early life are thinner than the record of what she did as an adult, and most of what is documented about her centers on her years as a licensed vocational nurse rather than her childhood. She trained as a nurse and began working in pediatric units in the late 1970s, eventually landing at Bexar County Hospital, a large public hospital that served as one of the primary children's care centers for the San Antonio region. She presented herself, in the accounts of doctors and parents who crossed paths with her, as deeply devoted to her smallest and sickest patients. She would hold dying infants for hours. She would cry at their bedsides. Colleagues who worked alongside her in the years before anyone suspected her described a nurse who seemed almost too emotionally invested in the children on her ward, a description that would later take on a far darker meaning. What built up underneath that devoted exterior was something investigators would spend years trying to fully map. Working in the pediatric intensive care unit gave Jones access to a population of patients who were already critically ill, children whose deaths or near deaths would not necessarily draw immediate suspicion, since many of them had arrived in genuinely fragile condition. According to the case that prosecutors would eventually build, Jones began using that access to inject children with substances that caused their hearts or their breathing to fail, then position herself as the nurse who fought to bring them back. Former colleagues and hospital administrators later told investigators they had noticed a pattern, that emergencies clustered around her shifts, that the same nurse seemed to be present for an alarming share of the unit's worst moments, and that she seemed to seek out the resulting crisis rather than dread it. The hospital, facing the threat of a public scandal and litigation rather than headlines, did not refer the matter to outside law enforcement. Instead, administrators quietly let Jones go in 1982, and rather than disclosing the suspicions that had built against her, the hospital gave her a positive reference that helped her find new work. That reference carried her to Kerr County, west of San Antonio, where a pediatrician named Dr. Kathleen Holland had just opened a small clinic in the town of Kerrville and was looking to staff it. Holland hired Jones in the spring of 1982, unaware of the unofficial nickname Jones had left behind her in San Antonio, or the quiet departure that had preceded the hire. For a short window of time, Jones worked in a clinic with far less oversight than a major hospital intensive care unit, fewer colleagues to notice patterns, and a doctor who trusted her experience. On August 30th, 1982, a 15-month-old girl named Chelsea McClellan was brought into that clinic by her mother, Petty McClellan, for a routine vaccination. Chelsea was a healthy toddler, the kind of patient pediatric clinics see constantly, in for a scheduled shot and nothing more. According to Petty McClellan's later testimony, Jones administered an injection to Chelsea while the child was still in her mother's arms, and almost immediately, the toddler began struggling to breathe. The injection contained a paralytic muscle relaxant called succinylcholine, a drug with legitimate uses in surgical settings to stop a patient's muscles from moving, but one that has no business being given to a healthy child receiving a vaccination. Chelsea was rushed to a hospital where she survived that first incident, but exactly 1 week later, on September 17, 1982, Jones administered another injection during a follow-up visit, and this time Chelsea did not survive. She died at Sid Peterson Memorial Hospital in Kerrville, and at the time her death was attributed to a seizure disorder rather than to anything a nurse had done to her. The pattern that had followed Jones from San Antonio followed her into Kerr County almost immediately. In the months Jones worked at Dr. Holland's clinic, the local community began noticing an unusual spike in children experiencing breathing emergencies after routine visits, a small-town version of the same suspicion that had quietly circulated through the Bexar County hospital staff. Local pharmacists noticed the clinic was ordering unusually large quantities of succinylcholine, a drug with limited legitimate use in an outpatient pediatric practice. A Texas Ranger named Joe Davis began looking into the unexplained pattern of medical emergencies tied to the clinic, and the investigation that followed eventually connected those emergencies directly to Jones and to the drug she had been ordering. Investigators exhumed Chelsea McClellan's body and ran toxicology tests that had not been part of the original examination. Those tests found succinylcholine in her remains, transforming what had been recorded as a natural death from a seizure disorder into a homicide. With that evidence in hand, a grand jury indicted Jones on charges connected to Chelsea's death and to the near-fatal poisoning of another infant in Bexar County, a 4-week-old boy named Rolando Santos, who had been given a near-lethal dose of a blood-thinning medication and had survived only because doctors caught the overdose in time. Jones went to trial in Georgetown, Texas, in February of 1984, after the case was moved out of Bexar County over concerns about finding an impartial jury. The trial built its case on the toxicology findings from Chelsea's exhumed body, on testimony from Petty McClellan describing the injection she watched her daughter receive, and on the pharmacy records documenting how much succinylcholine had been ordered for a small pediatric clinic that had no apparent use for that volume of a surgical paralytic. The defense argued that the evidence did not prove Jones had specifically administered the fatal dose. The jury was not persuaded. On February 15, 1984, Jones was convicted of murder in Chelsea McClellan's death, and, in a separate related case, of injury to a child in the near-fatal poisoning of Rolando Santos. She received a sentence of 99 years on the murder count. For more than 3 decades, that sentence appeared to settle the legal record on Janine Jones, even though investigators, journalists, and grieving parents in San Antonio continued to believe she was responsible for far more deaths than the one she had been convicted of causing. The number most frequently cited in connection with her suspected total runs as high as 60 children, a figure built from internal hospital reviews and statistical analysis of mortality spikes during her shifts, rather than from individual confirmed cases, and it has never been resolved into a precise, agreed-upon count. What changed the calculus around her case was not new evidence from the 1980s. It was an old Texas law. Jones had been sentenced under a mandatory release statute that existed in Texas during the 1970s and 1980s, specifically to relieve overcrowded prisons. A law that effectively guaranteed inmates sentenced during that window would be released after serving a fraction of their term, regardless of the severity of their crime. Under that law, Jones, despite her 99-year sentence, was on track to be released in 2018, after serving roughly a third of it. The prospect of one of the country's most prolific suspected child killers walking free set off alarm in Bexar County and renewed pressure on prosecutors to find a way to keep her behind bars. District Attorney Nico LaHood's office responded by reopening the cold cases connected to Jones's time at Bexar County Hospital, building new charges around infant deaths that had never been formally prosecuted as homicides. In 2017, a grand jury indicted Jones in the 1981 death of an 11-month-old boy named Joshua Sawyer, who had died after being given a lethal dose of an anti-seizure medication while under her care. The renewed investigation drew directly on the decades-old hospital mortality patterns and on toxicology evidence preserved from the original era, work that prosecutors had to essentially reconstruct using records and testimony that were now more than 30 years old. The case moved slowly through the courts, complicated by Jones's age and declining health, including a history of strokes that her attorneys argued affected her competency. In January of 2020, rather than face a new trial, Jones pleaded guilty to the murder of Joshua Sawyer. As part of the plea agreement, several additional related charges tied to other suspected victims were dismissed, a common trade-off in cases where prosecutors weigh the certainty of one conviction against the difficulty of proving decades-old allegations beyond a reasonable doubt. The judge who accepted the plea told Jones directly that the agreement did not come close to addressing what she had done to the families involved, and Jones was sentenced to life in prison, a sentence specifically structured to close off the mandatory release loophole that had threatened to free her 2 years earlier. At that sentencing hearing, family members of several of Jones's suspected victims were given the chance to speak directly to her, a kind of testimony that had not been possible in 1984 because so many of the underlying deaths had never been charged. Connie Weeks, the mother of Joshua Sawyer, told Jones she was relieved that her son's killer would die behind bars rather than walk free under a decades-old loophole. Other mothers, including relatives of children who were never formally tied to a charge at all, attended and spoke about losses that the legal system had never fully acknowledged as homicides. What stays in the public record about Janine Jones is the distance between the number of children believed to have died because of her and the number the legal system was ever able to formally pin to her name. A nurse who, by her co-workers' own private nickname for their unit, was understood on some level to be dangerous years before any outside agency acted on it. A hospital that chose a quiet dismissal and a positive reference over a referral to police. A small-town paediatric clinic that gave her a second hospital's worth of access to children with even less oversight than the first. A 15-month-old girl who went in for a vaccination and did not come home, and an 11-month-old boy whose death waited nearly 40 years for a courtroom. Janine Jones is currently serving a life sentence in a Texas prison, finally held, in the eyes of the law, for more than the single case that first put her away, though the full, true number of children who died at her hands during what colleagues once quietly called the death shift may never be fully known. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. Janine Jones turned a hospital nickname into 30 years of unanswered suspicion before the law finally caught up to the full scope of what she had done. The next case moves north to Ontario, Canada, where a nursing home employee named Elizabeth Wettlaufer spent nearly a decade quietly ending the lives of the elderly residents she was paid to care for, using a drug so ordinary that no one thought to look for it. Section 2. Elizabeth Wettlaufer. In the late summer of 2016, in a quiet office in London, Ontario, a nurse sat down with a psychiatrist and began to say out loud something she had been carrying silently for nearly a decade. She told him that she had been killing the elderly people in her care, one after another, for years, using a substance so common in any diabetic ward that no autopsy had ever caught it. The nurse was Elizabeth Wettlaufer, and the psychiatrist she confessed to had no formal obligation to report what she told him to police, since the conversation took place in a treatment setting rather than a courtroom. He chose to tell authorities anyway. Within months, a woman who had worked quietly across a string of long-term care homes in southwestern Ontario for nearly a decade and a half was under arrest, and the true scale of what she had done finally began to surface in public for the first time, unravelling a story that institutions, regulators, and coroners across the province had failed to notice for years. Elizabeth Tracy May Wettlaufer was born on January 10, 1967, and raised in Woodstock, Ontario, the daughter of devout evangelical Christian parents in a household by most accounts strict and tightly controlled. Friends and former classmates who later spoke to journalists described a young woman who grew up under heavy religious discipline, with little room for the kind of teenage independence many of her peers experienced. She trained as a registered nurse at Conestoga College, earning her qualification in the late 1990s, and entered a profession that, in long-term care settings especially, depends on a deep and largely unverifiable level of trust between caregivers, patients, and the families who hand their loved ones over for round-the-clock attention. Wettlaufer's career, viewed from the outside, looked unremarkable for years. She moved between several nursing homes in the Woodstock and London area, taking jobs at facilities including Crescent Care in Woodstock, where she worked for roughly a decade, beginning in 1995, and later Meadow Park in London, the ordinary career path of a nurse working in an industry that often shuffles staff between understaffed facilities in search of open shifts and steady hours. What was happening beneath that ordinary surface, beginning as early as 2007, was something almost no one in the Canadian healthcare system was equipped to catch. Wettlaufer began using insulin, a hormone her diabetic patients required to survive, and that nursing staff routinely administered as part of normal care, as a murder weapon. Insulin overdoses in elderly, frail patients can cause symptoms that closely resemble the natural decline doctors and families already expect to see in long-term care residents nearing the end of their lives. A coma, organ failure, an unexplained death that gets attributed to age and existing illness rather than to any external cause. Because insulin breaks down in the body relatively quickly and is not something coroners routinely test for in elderly patients who die in care facilities, Wettlaufer had, without ever needing to plan it with any particular sophistication, found a method that was nearly invisible to standard medical scrutiny. She had access to the medication carts, the patient charts, and the unsupervised hours of an overnight shift, the same access every nurse on her floor carried, and that ordinary access was the only tool she ever needed. Over the years that followed, Wettlaufer killed 8 residents in her care and attempted to kill 4 others, administering insulin overdoses to elderly men and women who trusted her as one of the staff members responsible for their daily medication. Her first victim was James Silcox, an 84-year-old resident at Crescent Care who died in August of 2007, killed with an insulin overdose Wettlaufer later admitted she gave him after becoming frustrated and overwhelmed during her shift. Over the years that followed, she went on to kill Maurice Granat, Gladys Millard, Helen Matheson, Mary Zurawinski, Helen Young, and Maureen Pickering, all residents at Crescent Care, before her final killing, Arpad Horvath, a resident at Meadow Park in London, in August of 2014, after she had moved facilities. The 4 residents she attempted to kill and who survived, Wayne Hedges, Michael Horvath, Clotilde Adriano, and a 4th resident, were given doses that, for reasons tied to their individual health or sheer chance, did not prove fatal, leaving behind survivors whose near deaths had also gone unexplained for years. Investigators later established that Wettlaufer's pattern was not connected to any consistent grievance against specific patients. Some accounts she later gave linked particular killings to moments of frustration or anger toward a patient or toward the demands of her job, describing a kind of compulsion that built during stressful shifts, while others appeared close to arbitrary, the act of a nurse who had crossed into something compulsive rather than calculated around any single motive or specific resentment. During the years she was killing patients, Wettlaufer's personal and professional life was not free of red flags, though none of them pointed clearly enough at murder for anyone to intervene. She struggled with addiction to narcotics, a problem serious enough that it eventually contributed to her being fired from Crescent Care in March of 2014, though her termination at the time was attributed to medication errors and unprofessional conduct rather than to any suspicion of intentional harm. The College of Nurses of Ontario, the regulatory body responsible for licensing and monitoring nurses in the province, was never formally notified of the specific reasons behind her dismissal in a way that would have flagged her file for closer scrutiny, a gap that the public inquiry into her case would later identify as one of the central systemic failures that let her continue working. She continued working in healthcare afterward, moving into other roles, including a stint providing in-home care through a private agency, still in positions where she had access to vulnerable people and to the medications that could harm them, before eventually leaving nursing altogether in the months before her confession. Throughout this period, the deaths she had already caused remained unconnected to her in the eyes of facility administrators, coroners, and regulators, scattered across different institutions and years, and explained away, case by case, as the unsurprising deaths of elderly, ill people in long-term care, the kind of deaths that rarely trigger a second look in a system already strained by high patient turnover and limited investigative resources. The unravelling began only when Wettlaufer herself decided to speak. In the summer of 2016, struggling with what she later described as the psychological weight of what she had done, and with worsening drug addiction, she admitted the killings during a stay at a mental health and addiction treatment facility in Toronto, telling a psychiatrist there the full extent of what she had been doing for nearly a decade. She reportedly also told a fellow patient in the facility and a former co-worker around the same period, suggesting that the secret had begun to feel unbearable to carry alone after so many years. The psychiatrist alerted the Toronto police, and authorities in Woodstock and London began an investigation that moved quickly once it had a credible confession to work from. Wettlaufer was arrested on October 25, 2016, and the charges that followed, 8 counts of first-degree murder and 4 counts of attempted murder, reflected the full scope of what her own statements had revealed, since without her confession, there had been essentially no investigative path that would have connected these deaths, spread across 2 facilities and 9 years, to a single nurse moving between several different care homes. Wettlaufer pleaded guilty to all charges in June of 2017, a decision that meant the case never went before a jury, and that the public record of what happened rests heavily on her own admissions and on the agreed statement of facts presented in court. At her sentencing hearing later that month, the court heard a detailed account of each killing, including her own descriptions, given to investigators, of how she selected patients and administered the fatal doses, often during routine medication rounds when no one else was watching closely enough to notice anything unusual. She described, in her own words read into the court record, a sense of compulsion that would come over her during certain shifts, an urge she said she did not fully understand, even as she acted on it. Family members of her victims were given the opportunity to address her directly in court, describing parents and grandparents who had gone into care expecting safety and had instead been killed by the very system meant to protect them. Several spoke about the years of unanswered grief that came before they ever learned the true cause of their loved one's death. Years spent believing they had simply lost someone to old age. On June 26, 2017, Justice Bruce Thomas sentenced Wettlaufer to life in prison, with no possibility of parole for 25 years, the most severe sentence available under Canadian law for multiple first-degree murder convictions. Because Canada does not have consecutive parole ineligibility periods stacked indefinitely for multiple murders in the way some other countries structure long sentences, the 25-year period applied as a single block, regardless of the number of victims, a detail that drew criticism from some of the families who felt the sentencing framework could not fully reflect the scale of what she had done. The judge, in his remarks, described her actions as a profound betrayal of trust, carried out against people who were among the most vulnerable members of society, residents who depended entirely on the staff around them for their basic survival. The case did not end with sentencing. The scale of Wettlaufer's killing spree and the years it had gone undetected across multiple regulated healthcare facilities prompted the Government of Ontario to convene a formal public inquiry, led by Justice Eileen Jalise, examining how a nurse could move between long-term care homes for nearly a decade while killing patients without triggering any institutional red flags. The inquiry held hearings over more than a year, taking testimony from co-workers, administrators, regulators, and family members, building a public record far more detailed than the criminal trial itself had produced, since Wettlaufer's guilty plea had closed off the kind of extended courtroom examination a contested trial would have required. The inquiry's findings, released in 2019, pointed to systemic problems, including inadequate medication oversight, insufficient reporting requirements when nurses were dismissed for misconduct, and gaps that allowed a fired employee with a documented history of medication issues to simply find work at another facility without that history following her in any meaningful way. The report made more than 90 recommendations aimed at long-term care reform, touching on staffing levels, medication tracking systems, and mandatory reporting between employers and the regulatory college responsible for licensing nurses across the province. The inquiry led to recommendations for tighter regulation of how long-term care homes screen, monitor, and share information about staff, an attempt to ensure that the specific blind spots Wettlaufer exploited could not be exploited again by someone else. Among the most significant proposed changes was a requirement that facilities report terminations tied to misconduct directly to the nursing college in a standardized way, closing the exact gap that had let Wettlaufer move from Crescent Care to other employment without her history surfacing. The Ontario government accepted many of the inquiry's recommendations in the years that followed, though family members of Wettlaufer's victims and advocates for long-term care reform have continued to push for faster and more complete implementation, arguing that some of the same staffing and oversight pressures that allowed her to operate undetected for 9 years remain present in the system today. What stays in the public record about Elizabeth Wettlaufer is the unsettling ordinariness of the method and the years it took before anyone outside her own conscience noticed. A substance every diabetic patient in her care needed to survive, turned into the means of killing 8 of them and harming 4 more, in a setting built specifically around the expectation of trust between staff and the families who could not be there every hour of every day. She was not caught by an alert colleague, a suspicious coroner, or a regulatory audit. She was caught because she told someone, voluntarily, after 9 years of silence that ended only when the weight of it became too much for her to carry on her own. Elizabeth Wettlaufer is serving her sentence at a federal prison in Canada, and the public inquiry her case forced into existence remains one of the most significant examinations of long-term care oversight in Canadian history, built entirely on the foundation of deaths that, without her own confession, might never have been understood as anything other than the ordinary end of long, difficult lives. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. Elizabeth Wettlaufer used the most ordinary medication in any nursing home to kill for nearly a decade before her own conscience turned her in. The next case moves to East Texas, where a dialysis nurse named Kimberly Saenz chose a substance far less ordinary and far more violent, turning the very machines meant to keep her patients alive into the instrument of their deaths. Section 3. Kimberly Saenz. On the afternoon of April 28, 2008, inside a DeVita-operated dialysis clinic in Lufkin, Texas, 2 patients sitting in adjoining chairs reported the same thing within minutes of each other, a sudden wave of feeling unwell that neither of them could explain. State health inspectors happened to be inside the clinic that very day, present because of an anonymous letter a local fire official had sent weeks earlier, pleading with state regulators to look into an alarming spike in emergency calls coming from the facility. While those inspectors were on the floor, 2 other patients reported watching a nurse inject something directly into the dialysis tubing of 2 of their fellow patients, Marva Roan and Carolyn Reisinger, a substance neither patient had requested and that had no place in their bloodstream. The nurse was a 28-year-old licensed vocational nurse named Kimberly Saenz, who had been working at the clinic for only about 8 months. Within days, she would be sent home, then arrested, then charged with one of the strangest and most chemically specific murder methods ever brought before an East Texas jury, killing dialysis patients by injecting ordinary household bleach into the lines that were supposed to be filtering their blood. Kimberly Saenz was born in 1973 and built an ordinary life in East Texas before her career took the turn that would define her. She married, had 2 children, and worked as a licensed vocational nurse, a credential that required less training than a registered nurse, but still placed her in direct, hands-on contact with patients undergoing serious medical treatment. In 2007, she took a position at the DeVita Dialysis Clinic in Lufkin, a satellite location of one of the largest dialysis providers in the country, a company that, by the early 2000s, operated or provided services to more than 1,800 facilities nationwide and served over 140,000 patients. The clinic in Lufkin served a population that depended entirely on the machines inside it. Patients with kidney failure, who came in multiple times a week, sat for hours connected to dialysis equipment that filtered toxins out of their blood because their own kidneys no longer could, and who had no choice but to trust the staff around them with every minute of that exposure. What made Saenz's chosen method so difficult for both her colleagues and, later, her jury to immediately grasp was its sheer ordinariness. Bleach is a substance every dialysis clinic keeps on hand in large quantities, used constantly to disinfect the plastic tubing and machine components that patients are hooked into, since dialysis equipment requires rigorous sterilization between uses to prevent infection. It was not a substance anyone needed to smuggle in or hide, and it was not unusual for staff to be seen handling it during a normal shift. What investigators would eventually argue is that Saenz took that completely unremarkable substance, present everywhere around her in the ordinary course of clinic operations, and used a syringe to inject it directly into the bloodlines of patients while they sat connected to dialysis machines, introducing a toxic chemical straight into their circulatory systems under the guise of routine clinical activity. The clinic had been showing signs of crisis for weeks before the day inspectors happened to be present. According to the Texas Department of Health Services, in the 2 weeks before state surveyors arrived, the clinic had needed paramedics to transport 16 patients, a number a local fire official described in his letter as abnormal and disturbing for medical crews who responded to the calls. Over the broader stretch of April 2008, emergency crews were called to the clinic roughly 30 times, including 7 calls specifically for cardiac problems, and made at least 19 transport runs. 4 patients had already died. By contrast, the clinic had generated only 2 emergency calls in the entire 15 months before that spike began, a statistic that made the sudden surge impossible to dismiss as ordinary variation once regulators started looking closely at the numbers. State medical surveyors arrived at the clinic within days of receiving the anonymous letter, and they happened to be present on April 28, 2008, the day Saenz was witnessed by 2 patients injecting something into the tubing of Marva Rohn and Carolyn Reisinger. The patients who witnessed this told inspectors directly, and the clinic responded immediately by sending Saenz home and calling police, before temporarily shutting down operations amid fears about ongoing patient safety. What followed was not an instant arrest. Investigators needed nearly a year to build a case substantial enough to bring capital murder charges, a process complicated by the unusual nature of the alleged weapon, and by the fact that bleach, unlike many poisons, is not something medical examiners routinely test for in patients who die during what looks, on its surface, like a medical complication consistent with end-stage kidney disease. During that year of investigation, detectives examined Saenz's home computer and found internet search history that prosecutors would later present as deeply incriminating, including searches related to bleach poisoning in blood and whether bleach could be detected in dialysis lines after the fact. When Saenz was called before a grand jury, she offered an explanation for those searches that became one of the central points of dispute at trial, telling the grand jury she had grown concerned about the unexplained pattern of patient deaths and had searched the topic herself to understand what the side effects of bleach exposure might look like, framing her own research as the curiosity of a concerned employee rather than the planning of a perpetrator. DeVita, the company that operated the clinic, eventually turned over more than 10,000 pages of internal records to investigators as the case built, material that included staffing schedules, incident reports, and documentation of the clinic's water purification and equipment maintenance procedures. Saenz was formally charged with 1 count of capital murder, a charge that in the indictment encompassed the deaths of as many as 5 patients, along with 5 separate counts of aggravated assault, tied to patients who survived injuries investigators attributed to bleach exposure. She pleaded not guilty and remained free on bail in the lead-up to trial, maintaining through her attorneys that she had been made a target by a company looking to deflect blame from its own operational failures, rather than confront the possibility that one of its own procedures, such as water purification problems at the facility, had caused the cluster of medical emergencies. The trial began on March 5, 2012, in Angelina County, nearly 4 years after the incidents that triggered it, and it would stretch on for almost a month, becoming one of the longest and most closely watched criminal trials in the region's recent history. Prosecutors built their case around eyewitness testimony from patients and staff who described seeing Saenz handle syringes filled with bleach near patient tubing, around the chemical analysis of dialysis lines that confirmed the presence of bleach where it should never have been found, and around the internet search history recovered from her computer. The defense, led by attorney Ryan Deaton, pursued a strategy built on procedural ambiguity, arguing that other staff members at the clinic also used syringes rather than measuring cups to mix bleach into cleaning solutions, which meant that being seen with a syringe near bleach was not by itself proof of murderous intent. A defense witness, a former co-worker, testified that he had personally seen other staff members use syringes for that exact cleaning purpose, while prosecution witnesses, other former DeVita employees, testified just as firmly that they had never used syringes that way and that the practice described by the defense witness was not standard at the clinic. The defense also argued that the high concentrations of bleach found in the blood lines that were eventually turned over to police could have entered those lines after the machines had already been shut down, suggesting there had been more than enough time and opportunity for the evidence to be contaminated or tampered with before it ever reached investigators, a theory aimed at undermining the chain of custody rather than directly contesting whether bleach had caused the patient's injuries. Saenz did not testify during the main portion of the trial, though her earlier statements to police and to the grand jury, describing her use of syringes and her concern about the deaths, were presented to jurors through other witnesses and records. The prosecution, led by District Attorney Clyde Harrington, dismissed the defense's central theory bluntly in closing arguments, describing the idea that DeVita had somehow framed Saenz for its own procedural failures as absolutely ridiculous, and instead pointed jurors back to the consistency between the eyewitness accounts, the chemical evidence, and Saenz's own internet searches into exactly how bleach poisoning would present and whether it could be traced. The jury deliberated for 2 days before returning its verdict on March 30th, 2012, finding Saenz guilty of capital murder in connection with the deaths of patients at the clinic and guilty on 3 additional counts of aggravated assault for patients who survived. The case then moved into a separate punishment phase, since Texas capital murder convictions carry only 2 possible sentences, death or life imprisonment without parole, and prosecutors had stated from the beginning that they intended to seek the death penalty, given the scale and method of the killings. During the punishment phase, Saenz's own attorney, Steve Taylor, argued directly to the jury that a life sentence, not death, was the appropriate outcome, telling jurors that society would still be fully protected because, in his words, she was never getting out, no matter what they decided. On April 2, 2012, the jury agreed, sentencing Saenz to life in prison without the possibility of parole, rather than death, a sentence that meant she would spend the remainder of her life behind bars, but would not face execution for the killings. The legal fight over the conviction did not end with sentencing. Saenz's defense appealed the capital murder conviction, and the case eventually reached the Texas Court of Criminal Appeals, the state's highest criminal court, which in December of 2014 ruled that the trial court had erred by allowing jurors to convict Saenz of capital murder without requiring them to unanimously agree on which specific victims, among the patients named in the case, she had actually murdered, since Texas law generally requires unanimous agreement on the specific underlying facts that support a conviction of this severity. That ruling sent the case back to a lower appellate court to determine whether the error was significant enough to overturn the conviction entirely. In 2015, Texas's Fourth Court of Appeals reviewed the case under that standard and ultimately upheld Saenz's capital murder conviction, finding that despite the technical error in how the jury had been instructed, the overall weight of the evidence in the record substantially supported a finding of guilt with respect to each of the patients named as capital murder victims, meaning the conviction and her life sentence remained in place. What stays in the public record about Kimberly Saenz is the unsettling simplicity of the weapon she chose and the months it took before anyone connected a string of medical emergencies to a single nurse working an entry-level position at a satellite dialysis clinic. A substance present in every supply closet of every clinic like it, used daily for entirely legitimate purposes, turned into a means of killing patients who were already among the most medically vulnerable people in any healthcare setting, tethered for hours at a time to machines that were supposed to be the thing keeping them alive. It took an anonymous letter from a frustrated fire official, a coincidental visit from state health inspectors, and the direct testimony of patients who watched the injections happen with their own eyes before anyone outside the clinic understood what had been happening inside it. Kimberly Saenz is serving her sentence in a Texas prison, her conviction upheld through years of appeals, and the dialysis clinic where she once worked remains, in the record of the case, a cautionary example of how easily a substance meant to disinfect a machine can be turned instead into the thing that kills the person connected to it. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. Kimberly Saenz turned a bottle of bleach into a murder weapon inside a clinic built to keep her patients alive. The next case moves to Southern California, where a coronary care nurse named Robert Diaz used the very heart medications meant to stabilize his patients to stop their hearts instead, becoming one of the most prolific hospital killers ever convicted in the United States. Section 4. Robert Diaz. On the night of March 30th, 1981, Robert Diaz began his very first shift in the intensive care unit of Community Hospital of the Valleys in Perris, California, a small community hospital roughly 70 miles southeast of Los Angeles. By the time that shift ended, a grandmother who had been a patient on the unit was dead, the first of what would become a tightly compressed string of fatalities over the following weeks. The hospital's coronary care unit had already been struggling before Diaz arrived, understaffed and repeatedly cited by state regulators for using vocational nurses rather than the registered nurses the unit was supposed to employ. What no one inside the hospital understood yet was that the man hired to fill one of those gaps had just begun what would become one of the most concentrated and lethal killing sprees ever carried out inside an American hospital. A stretch of roughly 12 days in which 12 patients would die, each one injected with a massive overdose of a heart medication that was supposed to save lives rather than end them. Robert Rubain Diaz was born in 1938 and trained as a licensed vocational nurse, a credential that allowed him to work in direct patient care without the more extensive training and licensing required of a registered nurse. By 1981, he had built a career moving through hospital positions in Southern California, eventually landing the position at Community Hospital of the Valleys in Perris. The intensive care and coronary care units of small community hospitals like this one depend heavily on a handful of nurses working overnight shifts with minimal additional supervision, since physicians are typically on call rather than physically present on the floor through the night, leaving nurses with substantial unsupervised access to medication carts, syringes, and the patients connected to monitoring equipment. That access, ordinary and necessary for the unit to function at all, was the only tool Diaz needed. In the 3.5 weeks following Diaz's arrival on the night shift, at least 13 patients in the coronary care unit suffered sudden, violent seizures, episodes that were almost always followed by cardiac arrest, respiratory arrest, or both. 9 of those 13 patients died. The nurses who witnessed these seizures, people with real clinical experience treating cardiac patients, described something they had never seen before in a coronary unit: convulsions that more closely resembled the grand mal seizures associated with epilepsy than anything connected to ordinary heart failure or cardiac arrhythmia. The unit's baseline mortality rate before Diaz arrived had already been running at roughly 20%. itself double what hospital administrators would normally expect, a problem regulators had flagged repeatedly in their inspections. After Diaz began working there, that rate climbed to nearly 50% of all patients admitted to the unit, a statistic so far outside any normal range that it eventually became impossible for hospital administration to explain away as ordinary bad luck or the simple severity of the patient's underlying conditions. The first formal break in the case came only after the hospital closed its intensive care unit entirely in response to the unexplained cluster of deaths, a drastic step that effectively shut down the source of the killings at that particular facility, at least for the moment. Diaz did not stop working as a nurse. He moved to a new position at San Gorgonio Pass Memorial Hospital in nearby Banning, California, and within only 3 days of his arrival there, while he was on duty, a patient died displaying the exact same pattern of symptoms that investigators had already begun documenting at Community Hospital of the Valleys: the sudden, violent seizure followed by cardiac and respiratory collapse. That single death at a second hospital, arriving so quickly after Diaz transferred there, was the detail that turned a vague pattern into a specific and urgent investigative lead, since it tied the same set of symptoms directly to the presence of one particular nurse across 2 separate institutions. Investigators moved quickly once that connection became clear. Within a day or so of the death at San Gorgonio Pass, Diaz was arrested and charged with murdering a total of 12 patients, a number that included 2 cases where witnesses had not directly observed the telltale seizures, but where investigators believed the pattern of deaths still matched. The investigation behind those charges required something unusual in any homicide case, since the original deaths had been recorded as natural, the unsurprising decline of elderly cardiac patients in a hospital already known for a troublingly high mortality rate. To build a case, investigators and the county coroner's office had to exhume bodies from local cemeteries, a grim and labour-intensive process that ultimately involved the exhumation or interception of close to 40 bodies in order to run toxicology tests that had never been part of the original death investigations. What those exhumations and tissue analyses found was unambiguous. Toxicologists discovered levels of lidocaine, a drug commonly used in hospitals to control irregular heart rhythms, that ran 10 to 20 times higher than what would be considered a normal therapeutic dose. Where an ordinary dose might run around 100 milligrams, the tissue samples from these patients showed concentrations in the range of 1,000 to 2,000 milligrams, a quantity with no legitimate medical purpose and every characteristic of a deliberately administered overdose. Lidocaine, used correctly, stabilizes a struggling heart. Used at the levels found in these patients, it instead causes the exact opposite effect, triggering the kind of violent seizures and cardiac arrest that nurses on the unit had already noticed and could not explain. The search of Diaz's own home added a further damning layer to the case against him. When investigators executed a search warrant there, they found discarded lidocaine packaging in his trash, along with vials that had been refilled with a concentration roughly 10 times stronger than what was printed on the original manufacturer's label, evidence that suggested deliberate tampering rather than any accidental mishandling of hospital supplies. Investigators also worked to establish a possible motive, building a psychological portrait of Diaz as a man who, according to the theory prosecutors and investigators developed, resented not having the status and authority of a physician, and who may have begun by deliberately worsening patients' conditions so that he could dramatically intervene and bring them back from the edge of death in front of doctors, manufacturing emergencies in order to manufacture his own heroism. The theory held that, at some point in that pattern, the act of pushing a patient toward death stopped being a means to an end and became something Diaz did for its own sake. Diaz's trial took place in Riverside County, and unlike many of the cases in this format, it was decided not by a jury, but by a judge sitting alone, a structure permitted under California law when a defendant waives the right to a jury trial. Diaz took the stand in his own defense and denied committing any of the murders, but he was never able to offer the court an alternative explanation for how such extraordinarily high concentrations of lidocaine had ended up in the bodies of patients who had died under his care, nor for the refilled vials and discarded packaging found in his own home. After weeks of testimony covering the medical evidence, the exhumations, the toxicology findings, and the pattern connecting Diaz's shifts to the deaths at 2 separate hospitals, the judge convicted him on all 12 counts of murder. The case then moved to its penalty phase, conducted in a single day, where prosecutor Patrick Majors argued forcefully that Diaz deserved the harshest sentence California law allowed. Majors told the court that Diaz had been in a position of trust and confidence with every one of his victims, and that he had betrayed that trust and ended a dozen lives for nothing more than his own amusement or enjoyment. Language meant to underscore that this had not been a case of negligence or even a single catastrophic error, but a sustained pattern of intentional killing carried out by someone whose job existed specifically to protect the people he was murdering. Riverside County Superior Court Judge John Barnard rejected the defense's request for leniency and, on April 11, 1984, formally sentenced Robert Diaz to death in the California gas chamber, a sentence that reflected the conviction on all 12 murder counts. Diaz spent the next 26 years on death row at San Quentin State Prison, maintaining his innocence throughout that entire span and never offering any account of the lidocaine found in his victim's tissue or in his own home that contradicted the prosecution's case. California's long-running legal and procedural delays in capital cases meant that, despite his death sentence, no execution date was ever set during those decades, a pattern common to many California death row inmates, given the state's history of extended appeals processes and periods without active executions. On August 11, 2010, Diaz died of natural causes inside San Quentin at the age of 72, one of 51 condemned inmates at the prison who had died from natural causes since California reinstated capital punishment in 1978, a tally that prison officials noted was considerably larger than the number of inmates who had been executed or who had taken their own lives over that same period. Diaz's victims ranged in age from 52 to 95, a span that captured both relatively younger cardiac patients and the truly elderly, all of them admitted to a coronary care unit because their hearts were already failing them in some way, and they needed exactly the kind of careful, trustworthy monitoring that a hospital nursing staff is supposed to provide. State officials declined to release information about how many of his victims had surviving family members able to see the case through to its conclusion, and unlike several of the other cases in this collection, no single advocacy campaign or piece of legislation emerged publicly in connection with Diaz's crimes, a difference that reflects, in part, how long ago the case unfolded and how completely it predates the modern infrastructure of victim advocacy and legislative response that later cases would generate. What stays in the public record about Robert Diaz is the sheer compression of the violence. 12 confirmed murders carried out in roughly 12 days, inside a hospital unit that was already failing the patients it was supposed to protect before he ever arrived. A nurse who needed only the ordinary tools of his job, a syringe and access to medication every coronary patient might plausibly receive, to turn a heart-stabilizing drug into a weapon capable of killing with terrifying speed and consistency. A pattern of violent, unexplained seizures that experienced nurses recognized as abnormal almost immediately, even as the hospital took weeks to act on what they were seeing. Robert Diaz spent more than a quarter century on death row before dying there of natural causes, having never explained, in a single sentence, how the bodies of a dozen of his patients came to hold 10 to 20 times the lidocaine any doctor would have ordered for them. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. Robert Diaz turned a heart medication into a murder weapon over the course of 12 days, killing faster and more openly than almost any caregiver on this list. The next case crosses the Atlantic to a small town in Bavaria, where a German nurse named Stefan Letter spent more than a year quietly ending the lives of patients he claimed he was only trying to help. Section 5. Stefan Letter. In late January of 2003, less than a month after a young nurse named Stefan Letter began working on the internal diseases ward of a hospital in Sonthofen, a small town in the Bavarian Alps in southern Germany, the pattern of deaths on that ward began to shift in a way that almost nobody noticed at the time. Sonthofen was a quiet community, the kind of place proud enough of its surroundings to be named the Alpine Town of the Year only a couple of years later, and its hospital served a population that was, like much of rural Bavaria, heavily weighted toward the elderly. Patients on a ward like that die regularly, a fact of geriatric medicine that hospital staff are trained to expect rather than question. What investigators would eventually establish is that over the 18 months that followed Letter's arrival, more than 80 deaths occurred during his individual shifts, an astonishing concentration that, once finally examined, pointed to one of the largest serial killing cases in German history since the end of the Second World War. Stefan Letter was born on September 17, 1978, in Herdecke, in the North Rhine-Westphalia region of West Germany, and trained as a nurse before taking the position at the hospital in Sonthofen in January of 2003. He was only 24 years old when he started there, and by every outward measure, he was an ordinary young nurse, working a demanding ward filled with elderly, frequently terminal patients. The internal diseases ward where he worked treated patients with a wide range of chronic and acute conditions, many of them in their 70s, 80s and 90s, the kind of population where a death is rarely treated as suspicious on its own. That ordinary expectation of mortality, the same quiet camouflage that has protected nearly every caregiver in this format, gave Letter cover for a year and a half. The method Letter used was built around drugs that were already present on his own ward, in significant supply, removing the need for him to bring in anything that would draw outside attention. He stole quantities of a tranquilizer and a muscle relaxant called Listhenon from hospital stores, and when administered together in combination, at the doses he chose, the two drugs caused respiratory failure and death, a mechanism that, especially in already frail elderly patients, could closely resemble the kind of sudden cardiac or respiratory decline that hospital staff already associated with this patient population. He did not need a sophisticated poison or an exotic substance. He needed access to a supply closet that any nurse on his ward could reach, and the patients to use it slowly enough that no single death raised an immediate alarm. The deaths that occurred on Letter's shifts spanned a population ranging in age from 40 to 94, though the overwhelming majority of his victims were older than 75. Patients whose families and physicians were often already bracing for the possibility of decline given their existing conditions. He did not confine his actions strictly to patients who had been formally assigned to his care. Investigators later found that in some instances, Letter had administered fatal injections to patients who were not on his own patient list and who were, in fact, in stable condition and scheduled to be discharged from the hospital, a detail that undercut any claim that his actions could be understood purely as an extension of caring for patients already under his direct responsibility. In one case that drew particular attention during the investigation, Letter gave an inappropriate injection to a 22-year-old soldier who had been admitted with only minor injuries from a fall, a patient with no terminal condition and no plausible justification for any kind of mercy intervention, and she lost consciousness before ultimately recovering, one of only 2 known victims who survived an attack that was otherwise consistent with his pattern. What finally exposed Letter was not a suspicious doctor or a grieving family member, but an inventory discrepancy, the kind of administrative detail that exists specifically to catch exactly this sort of theft. Hospital officials noticed that large quantities of medication, including the muscle relaxant Listhenon, had gone missing from the ward's supplies, a shortfall significant enough to trigger an internal review rather than being written off as routine waste or miscounting. That review eventually pointed investigators toward Letter, and when police searched his apartment, they found unsealed medication vials among his belongings, drugs that had no legitimate reason to be sitting in a nurse's home rather than locked inside a hospital's controlled medication storage. Letter was arrested on July 29, 1934, in the summer of 2004, just before what would have been the next deadly cycle on his ward, ending an 18-month run that had begun in January of 2003. The scale of the subsequent investigation reflected just how much ground prosecutors needed to cover. Officials moved to exhume the bodies of more than 40 patients whose deaths during Letter's shifts had originally been recorded as natural, hoping that toxicology testing on those remains could establish definitive evidence of the drug combination believed to have killed them. The investigation ran into a hard limit almost immediately, since another 38 patients who had died under circumstances consistent with the pattern had already been cremated, destroying any physical evidence that could have connected those specific deaths to Letter beyond the statistical anomaly of his shift schedule. Investigators were left working with an unusually wide gap between the number of deaths they statistically associated with his presence, more than 80, and the smaller number they could ultimately support, with hard toxicological proof sufficient to bring formal charges. Letter went on trial in February of 2006 in the Bavarian town of Kempten, charged in connection with 29 patient deaths, broken down into 16 counts of murder, 12 counts of manslaughter, and 1 count of killing on request, the German legal term for a mercy killing carried out at a patient's own expressed wish, along with a separate charge of attempted manslaughter tied to the surviving soldier. At the outset of the 9-month trial, Letter admitted that he had given patients on the ward lethal injections using drugs stolen from hospital supplies, but he firmly denied that he had acted with malice. He testified that he had killed patients because he could not bear to watch them, in his own words, wasting away, framing his actions as an act of compassion toward people he believed were already suffering beyond any hope of meaningful recovery. When asked directly how many patients he had killed, he said at the outset of the trial that he could not remember the precise number, a statement that, set against the more than 80 deaths recorded during his shifts, only deepened the uncertainty around the case's true scope. The prosecution rejected Letter's framing outright, pointing to the cases involving patients who were stable, scheduled for discharge, or, in the case of the young soldier, suffering from nothing remotely terminal, as evidence that his stated motive of relieving suffering could not account for the full pattern of his actions. Over the course of the 9-month trial, which by all accounts stunned the small, tightly knit mountain community surrounding Sonthofen, the court worked through the medical and toxicological evidence tied to each of the 29 charged deaths, along with testimony establishing Letter's access to the missing drugs, and the timeline connecting his presence on shift to the pattern of fatalities. On November 20, 2006, the court in Kempten delivered its verdict. Letter, by then 28 years old, was found guilty of 12 counts of murder, 15 counts of manslaughter, and 1 count of killing on request, along with the separate attempted manslaughter charge tied to the soldier who survived. Presiding Judge Harry Reckner sentenced him to life imprisonment, the maximum penalty available under German law, with the court's finding on the particular severity of his crimes ensuring that the standard minimum term, before any possibility of release, would not apply in any meaningful way to a case of this scale. During the sentencing, witnesses in the courtroom described Letter as visibly overcome, his shoulders shaking as the verdict was read, and he turned first to his own defense attorney, who had spent the trial presenting him as a mercy killer, tormented by the suffering he witnessed around him, and then toward the public gallery, where relatives of his victims had gathered to see the case reach its conclusion. He appeared to mouth a short apology in their direction before the proceedings closed. At the time of his conviction, Letter's case was described as the largest killing spree in Germany since the end of World War II, a grim record that would itself eventually be surpassed. In 2019, another German nurse, Niels Hogel, was convicted of murdering 85 patients across 2 different hospitals in the northwestern part of the country, a case that displaced Letters as the worst of its kind in the country's modern history, and underscored just how repeatedly the same structural vulnerability, unsupervised access to medication on understaffed overnight hospital shifts, has allowed individual caregivers in Germany alone to kill on a scale that took investigators years to even partially reconstruct. Letter has been held at the Straubing prison in Bavaria since his conviction, serving the life sentence handed down in Kempten. German media reported in the years following the trial that investigators continued to examine several additional suspicious deaths that could potentially be traced back to his time at the Sonthofen hospital. Deaths that fell outside the 29 cases formally charged, but that fit the broader statistical pattern associated with his shifts. A reminder that even a conviction built around 29 specific deaths likely understated the full toll of what happened on that ward between January of 2003 and July of 2004. What stays in the public record about Stefan Letter is the gulf between the explanation he offered and the pattern the evidence actually supported. A young nurse who described himself as someone who could not stand to watch his patients decline applied that justification to a soldier with minor injuries and to patients who were stable enough to be sent home, and built an 18-month pattern of death out of medication that was sitting, unremarkably, in his own ward's supply closet. More than 80 deaths occurred during his shifts. 29 were formally charged. 38 bodies could never be tested at all, already lost to cremation before anyone thought to ask the question that should have been asked much sooner. Stefan Letter remains in custody in Germany, serving a life sentence for a killing spree that, for a time, stood as the worst the country had seen since the war, in a small alpine town that had no reason to expect that the danger inside its hospital wore scrubs and carried a badge that said he was there to help. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. Stefan Letter hid behind a claim of mercy while killing patients who were never close to death at all. The next case moves to Florida, where a nurse named Brian Rosenfeld was caught after only 3 confirmed killings, even as a former cellmate later claimed the true number stretched into the dozens. Section 6. Brian Rosenfeld. In the spring of 1990, an 82-year-old man named Alphonse Silva was admitted to Rosedale Manor Nursing Home in St. Petersburg, Florida, recovering from treatment for throat cancer, the kind of patient a nursing home exists specifically to help. His son, Art, would later describe the family's hope plainly, that Rosedale Manor would give his father the support he needed to eventually recover and come home. Not long after Alphonse settled in, he died, and his family, given no reason to suspect otherwise, believed the cancer had simply taken him. It would be 10 weeks before anyone at the Florida Department of Child and Family Services opened an investigation into a Rosedale Manor nurse named Brian Rosenfeld, a delay that, by the time the full case was finally assembled, would prove to be only one small piece of a pattern that had been building across more than a dozen nursing homes for the better part of a decade. Brian Kevin Rosenfeld was 34 years old by the time his case finally closed in court, and the picture investigators built of his career painted a man who had been moving through the Florida nursing home system for roughly 10 years before anyone managed to stop him. Over that decade, Rosenfeld worked at as many as 20 different nursing homes in the Pinellas County area and was dismissed from 14 of them, a startling figure that reflected just how many separate facilities had picked up on some kind of problem with him without any of those individual terminations triggering a wider investigation or even a meaningful warning passed between employers. Some of the homes that let him go later cited patterns of patient abuse that had nothing directly to do with murder, but that, in hindsight, painted the portrait of a caregiver who treated the people in his charge with casual cruelty. Colleagues told investigators that Rosenfeld would bend patients' fingers back until they screamed in pain, would shove food down their throats until they gagged, and would pull and snap back catheter tubing, behaviour that several co-workers had witnessed directly and that several facilities had used as grounds for dismissal without ever connecting it to the broader question of whether his patients were dying at an unusual rate. The structural problem underlying Rosenfeld's decade of movement between facilities was one that would recur across multiple cases in this format. Nursing homes in this period rarely shared detailed disciplinary histories with one another, and a caregiver fired for misconduct at one facility could often simply apply at another nursing home a few miles away and be hired without that history following him in any formal way. Rosenfeld exploited that gap repeatedly, landing new positions even after being let go from over a dozen previous jobs, each new home treating him as a nurse with no documented history of serious wrongdoing, rather than as someone who had already been removed from more than a dozen other facilities for cause. The deaths that would eventually be tied to Rosenfeld followed a similar method across multiple victims, lethal injections of medications that had no place being administered in the doses he chose. Hazel DeRima, an 81-year-old resident of Sunshine Village in Pinellas Park, Florida, died after being given a fatal injection of thioridazine, an antipsychotic medication sold under the brand name Mellaril, in a dose investigators would later determine was massive enough that one Associated Press account described it as enough of the drug to kill an elephant. Muriel Watts, a patient at Rosedale Manor, was murdered the same way, given a lethal injection of thioridazine, with 2 nurses on duty reporting that they had observed the comatose woman receive an unusually large dose of a brown liquid through her feeding tube shortly before she died. An observation that, unlike so many of Rosenfeld's other victims, actually generated a direct eyewitness account tying him to the act, rather than relying purely on later toxicology. The Watts case carried a particular weight once investigators reconstructed the full timeline, because it became clear that her death had been preventable in the most direct sense possible. Shortly before Watts was killed, Rosenfeld had already been convicted of stealing Demerol, a controlled narcotic painkiller, from a terminal patient at the facility where he was working, a conviction serious enough that it should have ended his employment outright. The nursing home did not fire him. He remained on staff, with continued access to patients and medication, and went on to kill Watts not long afterward, a sequence that led directly to the grim conclusion, later voiced by people reviewing the case, that had the home simply terminated him after the theft conviction, Watts would very likely still have been alive. The investigation that eventually built a case against Rosenfeld grew out of the call to Florida's elder abuse hotline regarding the Rosedale Manor nurse, received by caseworker Helen Gasky Brummer on July 31, 1990. Investigators sent blood and gastric content samples from Watts for laboratory analysis, even though her initial autopsy had shown no external signs of injury and no immediately obvious cause of death, the same kind of ambiguous picture that had let so many of Rosenfeld's other victims pass without scrutiny. The toxicology results that eventually came back told a different story, revealing that Watts's blood contained toxic levels of acetaminophen, along with roughly 5 times the normal therapeutic dose of thioridazine, concentrations with no plausible accidental explanation. Around the same period, a detective named Vaughan met with Rosenfeld directly at his apartment to discuss the mounting complaints against him, and Rosenfeld dismissed the accusations as nothing more than malicious claims from co-workers or families who, in his telling, simply did not understand the realities of nursing home care. As the investigation widened, police began examining Rosenfeld's full employment history across the various Pinellas County facilities where he had worked over the preceding decade, a process that quickly ran into the same evidentiary wall that has limited nearly every case in this collection involving suspected serial medical killers. Many of the patients who had died during Rosenfeld's various postings had already been cremated long before anyone suspected foul play, destroying any possibility of running the kind of toxicology testing that had finally caught up to him in the Watts case. Florida Assistant State Attorney Fred Schaub told a judge that across the full span of Rosenfeld's career, 201 deaths had occurred during his various stints at different nursing homes, and that of those 201, a staggering 170 bodies had already been cremated before any suspicion about the manner of their deaths was ever raised. A number that effectively guaranteed the official case against Rosenfeld would only ever capture a fraction of what investigators privately believed he had done. Working with the smaller pool of cases where exhumation and toxicology remained possible, authorities pursued bodies buried across 5 different states, eventually building confirmed evidence in 3 deaths. Through exhumation and autopsy, investigators were able to pin one 1987 murder on Rosenfeld, along with the 2 1990 deaths of Watts and DeRima, and Rosenfeld was indicted on charges connected to all 3. He was also separately charged with practicing nursing without a valid license at points during his career, a charge that reflected the broader picture of someone who had repeatedly slipped through the credentialing and oversight systems meant to keep dangerous caregivers out of patient care entirely. Facing the possibility of a death sentence if the case went to trial, Rosenfeld agreed to plead guilty to all 3 murders rather than contest the charges in court. In April of 1992, Pinellas Pasco Circuit Court Judge Claire K. Luton accepted the plea agreement and sentenced Rosenfeld to 3 concurrent life terms, with no possibility of parole for 25 years. Reporters who watched the hearing described Rosenfeld as meek, pudgy, and pale in his jailhouse attire, a physical presentation that struck several observers as strikingly at odds with the violence attributed to him, before he quietly admitted to the murders and accepted the sentence that closed out what had become a massive 2-year investigation touching on the full scope of those 201 deaths across 14 nursing homes. Pinellas County Medical Examiner Joan Wood, who had overseen much of the forensic work behind the case, told reporters at the time that she had no doubt the 3 confirmed murders represented only part of what Rosenfeld had actually done, and she offered a blunt explanation for why so much of his career had gone unexamined for so long. "No one thinks twice," she said, "when a sick, elderly person dies in a nursing home, and that basic assumption, reasonable in any individual case but devastating in aggregate, had allowed homicidal caregivers to escape detection for years at a time." She added that if anyone had ordered an autopsy on Rosenfeld's earlier victims when they first died, investigators almost certainly would have caught him sooner, a statement that placed at least part of the blame not on any single failure, but on a broader system that treated nursing home deaths as inherently unremarkable. After his conviction, accounts surfaced suggesting the true number of Rosenfeld's victims may have run far beyond the 3 he was formally convicted of killing. A former cellmate later told investigators that Rosenfeld had boasted privately about killing as many as 23 patients over the course of his career, a figure that, if true, would place him among the more prolific caregiver killers documented in the United States, though prosecutors were never able to independently verify that number, given how many of the underlying bodies had already been cremated. Whether the true total reaches anywhere near that figure remains, by design of the cremation policies that destroyed the relevant evidence, something that can likely never be definitively settled. What stays in the public record about Brian Rosenfeld is the staggering gap between the number of deaths investigators believed were connected to him and the number the legal system was ever able to formally prove. A nurse fired from 14 different nursing homes over roughly a decade, never stopped by any of those individual terminations from finding the next job at the next facility. A theft conviction that should have ended his access to patients, and instead preceded one more murder. 201 deaths occurring during his various postings, with 170 of the bodies already turned to ash before anyone thought to ask whether they deserved a second look. Brian Rosenfeld remains in a Florida prison, serving his life sentence, convicted of 3 murders that medical examiners, investigators, and even his own former cellmate have all suggested were only a small fraction of what actually happened across the homes where he was trusted to provide care. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. Brian Rosenfeld left behind a trail of 200 deaths and only 3 the law could ever prove. The next case leaves the world of hospitals and nursing homes entirely, moving to a New York City apartment where a hired nanny named Yoseline Ortega turned an ordinary afternoon of childcare into one of the most devastating crimes the city had seen in years. Section 7. Yoseline Ortega. On the afternoon of October 25, 2012, Marina Krim came home to her Upper West Side apartment in Manhattan with her 3-year-old daughter, expecting to find the same scene she had walked into countless times before, her nanny finishing up the day with her 2 younger children. Instead, she opened the bathroom door and found her 6-year-old daughter, Lucia, known to everyone as Lulu, and her 2-year-old son, Leo, lying in the bathtub, their throats slit, their eyes open. The woman responsible was Yoseline Ortega, the nanny Marina and her husband Kevin had hired roughly 2 years earlier to help care for their children while Marina spent time with their oldest, and who had been, by every outward measure, a trusted and familiar presence in their home. Ortega was still in the apartment when Marina made the discovery, and as Marina screamed, Ortega turned the same knife on her own throat in an apparent attempt to take her own life, though she ultimately survived. The case that followed would become one of the most closely watched child murder trials in recent New York history, not because the facts of what happened were ever seriously in dispute, but because of the question that consumed the courtroom for 6 weeks afterward: whether the woman who did it could be held criminally responsible for it. Yoseline Ortega was 50 years old at the time of the killings, an immigrant from the Dominican Republic who had worked as a nanny in New York City for years before the Krim family hired her. She had been employed by Marina and Kevin Krim for approximately 2 years by the time of the murders, working in their home regularly enough that she had become a familiar fixture in the lives of their children, the kind of caregiver parents in large cities depend on heavily, often without much formal vetting beyond word of mouth and a sense of personal trust built up over repeated interactions. To the Krims, Ortega was the woman who picked their children up from activities, who fed them, who put them down for naps, the person who made it possible for a working mother in Manhattan to manage the logistics of raising 3 young children. Nothing in the relationship, at least from the family's side, suggested any reason for alarm. What was happening beneath that ordinary working relationship, in the weeks and months leading up to the murders, would become one of the central disputes of the entire case. Prosecutors built a narrative grounded in resentment over money, arguing that Ortega had grown deeply upset over disputes related to her wages and working hours, and that this resentment had built into the motive behind a premeditated and deliberate act of violence against 2 children who had nothing to do with the financial disagreement itself. The defense offered a starkly different account, arguing that Ortega had been suffering from severe, undiagnosed mental illness, including psychosis and dissociation. Conditions, her attorneys argued, left her unable to understand or control her actions at the moment of the killings. Both sides agreed on what had physically happened in that bathroom. The trial existed almost entirely to determine why, and whether that why mattered under the law. The killings themselves took place on a weekday afternoon, while Marina was out with her oldest daughter, the ordinary rhythm of a family's schedule that placed Ortega alone with Lulu and Leo for what should have been an unremarkable stretch of childcare. According to the case prosecutors built and presented at trial, Ortega used a kitchen knife to kill both children in the bathroom of the apartment, inflicting fatal wounds to their throats. Assistant District Attorney Courtney Groves, describing the scene Marina walked into, told the court that she found the bloodied, lifeless bodies of her 6-year-old daughter and 2-year-old son, their eyes open, covered in blood. A description that captured both the physical horror of the scene and the unbearable suddenness with which an ordinary afternoon had turned into the worst moment of a mother's life. Marina's own account of the discovery, given during her testimony, described a horror that she said she had never imagined possible, and at one point she recalled the moment with words that captured the depth of her relationship with the children she had lost, telling the court that Ortega had killed her best friends. Ortega remained in the apartment after the killings, and as Marina's screams brought the horror of the scene into the open, Ortega turned the knife on her own throat. She survived the attempt, severely injured but alive, and was taken into custody not long afterward. There was no question of identifying a suspect or building a circumstantial case from indirect evidence, the way so many of the other cases in this collection required months or years of careful investigative work simply to determine who had been responsible. Ortega was found at the scene, with the children's blood on her, having attempted and failed to end her own life in the aftermath of theirs. The case moved toward trial over the following months, with prosecutors charging Ortega with 2 counts each of first-degree and second-degree murder in connection with the deaths of Lucia and Leo Krim. Ortega's defense team, led by attorney Valerie Van Leer Greenberg, signaled early that they intended to pursue an insanity defense, arguing that severe mental illness, rather than calculated rage or premeditated intent, was the true explanation for what had happened. That defense strategy set the stage for a trial that would spend far more time examining Ortega's psychological state than litigating any disputed factual question about what physically occurred in the apartment that afternoon. The trial opened in Manhattan and ran for approximately 6 weeks, drawing testimony from psychiatric experts on both sides, who reached sharply different conclusions about Ortega's mental state at the time of the killings. The defense called doctors and psychiatrists who testified that Ortega suffered from psychosis, depression, and dissociation, with her attorney describing to the jury a defendant who had heard voices telling her to kill the children, and arguing in closing remarks that the true reasons behind her actions lay within what Van Leer Greenberg called her client's delusional mind, a phrase aimed directly at the legal standard New York law requires for an insanity defense to succeed, that a defendant lacked the capacity to understand the nature or wrongfulness of their actions. Prosecutors pushed back forcefully against that framing, arguing instead that Ortega had understood precisely what she was doing in the moments leading up to the killings. Assistant District Attorney Stuart Silberg told the jury during closing arguments that every stab, every slash, had a purpose, and that the purpose was unmistakably to end the lives of the two children in her care. A statement meant to underscore that Ortega's actions reflected deliberate intent, rather than a break from reality severe enough to meet the legal threshold for insanity. The jury, a 12-member panel, deliberated for 2 days before reaching its verdict. On April 18, 2018, the jury rejected Ortega's insanity defense and found her guilty on all counts: 2 counts of first-degree murder and 2 counts of second-degree murder for the killings of Lucia and Leo Krim. Kevin Krim, the children's father, broke down in tears upon hearing the verdict, and outside the courtroom, he later described hugging as many of the jurors as he could reach, a small, raw gesture of gratitude toward the 12 people who had spent 6 weeks absorbing the worst details of his family's loss in order to reach a judgment. Ortega's sentencing followed the conviction by several weeks. On May 14, 2018, she was sentenced to life in prison without the possibility of parole, the most severe sentence available under New York law for the crime she had been convicted of committing. The sentence ensured that Ortega, by then 55 years old, would spend the remainder of her life in custody, closing the legal chapter of a case that had already, by the time of sentencing, profoundly reshaped how the family at its center understood the idea of trust inside their own home. The case left ripples that extended well beyond the courtroom. The killings, occurring as they did to 2 young children left in the temporary care of someone their parents trusted completely, struck a particular nerve among working parents across the country who depended on similar caregiving arrangements, and the case drew international news coverage throughout the investigation and trial. It later inspired a best-selling French novel exploring the complicated relationship between a working mother and the nanny she hires to help raise her children, a fictional treatment that drew directly on the unsettling questions the real case had raised about how much can truly be known about the person left alone with a family's most vulnerable members. Marina Krim, in the years following the murders, became an advocate connected to grief and parental loss, channeling her experience into public efforts aimed at supporting other parents facing similarly unimaginable losses, while continuing to raise her surviving daughter amid a loss that reshaped every part of the family's life. What stays in the public record about Yoseline Ortega is the speed and totality with which an arrangement built entirely on trust collapsed into the worst possible outcome a parent can imagine. A nanny employed for 2 years, present in countless ordinary afternoons of snacks and naps and trips to the park, who turned a single weekday afternoon into a crime that shocked a city and reached readers an ocean away through a novel inspired by its central, unbearable question. The dispute over her motive, financial resentment against severe mental illness, was argued for 6 weeks in a Manhattan courtroom and ultimately resolved in the jury's 2 days of deliberation, a judgment that found her fully responsible under the law for what she had done. Yoseline Ortega is serving a sentence of life without parole, and Lucia and Leo Krim, 6 and 2 years old at the time of their deaths, remain frozen at those ages in the memory of a mother who has spent the years since trying to build something meaningful out of a loss she has described as the destruction of her own best friends. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. Yoseline Ortega turned 2 years of trust into a single unbearable afternoon inside the family's own home. The next case rewinds 2 decades to Massachusetts, where a young British au pair named Louise Woodward became the centre of an international legal storm after an infant in her care did not survive the violence she inflicted on him. Section 8. Louise Woodward. On the morning of February 4, 1997, in the suburb of Newton, Massachusetts, a 19-year-old British au pair named Louise Woodward placed a call to 911, telling the dispatcher that the 8-month-old baby in her care was barely breathing. The baby was Matthew Eapen, the younger of 2 sons belonging to doctors Sunil and Deborah Eapen, a working couple who had hired Woodward through a formal au pair placement agency to provide live-in childcare while they pursued their medical careers. Matthew was rushed to Boston's Children's Hospital, where doctors found a constellation of injuries that told a story far more violent than a simple fall or accident: a skull fracture, bleeding between his skull and brain, and bleeding at the back of his eyes. Injuries that, taken together, doctors concluded were consistent with what is medically known as shaken baby syndrome. Matthew never regained consciousness. He was taken off life support 5 days later, on February 9, 1997. Woodward, arrested the day after her 911 call, would spend the months that followed at the centre of one of the most closely watched and bitterly contested child homicide trials of the decade. A case that ultimately turned not on whether she had caused Matthew's death, but on what, exactly, the law should call what she had done. Louise Woodward was born in 1978 in Elton, Cheshire, in the northwest of England, and came to the United States in the mid-1990s as part of a gap year programme common among British teenagers in that era. Working as a live-in au pair through Cultural Care Au Pair, a placement service operated under the larger EF Education First organisation. She was 19 years old at the time she was hired by the Eapens, young enough that the case would later become, in the eyes of many commentators, as much a referendum on the entire au pair system as it was a trial of one specific defendant. Critics of the system pointed out that au pairs in Woodward's position frequently received minimal formal childcare training before being placed, alone, in homes with infants and toddlers, often far from their own families and support networks, a structural gap her own defence would eventually lean on heavily in explaining what had gone wrong inside the Eapen household. At the time of the incident, Woodward had been responsible for Matthew and his 2-year-old older brother while their parents were at work, an ordinary arrangement repeated daily in households across the country where 2 working parents depend on a single caregiver to manage hours alone with young children. According to the case prosecutors built, on the morning in question, Matthew became unresponsive while in Woodward's sole care, and the explanation she initially offered investigators did not match what the medical evidence in his small body would go on to reveal. Doctors at Children's Hospital identified massive brain damage, alongside the skull fracture, subdural hematoma, and retinal hemorrhaging that, in combination, are commonly associated with a baby having been violently shaken and, in many clinical assessments, also slammed against a hard surface. Woodward was arrested on February 5, 1997, the day after her emergency call, and was formally charged with first-degree murder in March of that year, once Matthew's death had been confirmed and the medical findings had been fully documented. The case against her rested heavily on the prosecution's medical experts, who told the jury that Matthew had suffered 3 particularly significant injuries: the subdural hematoma, the retinal bleeding, and pronounced brain swelling, a combination that, in their clinical judgment, pointed clearly and specifically toward the violent shaking and impact mechanism associated with shaken baby syndrome rather than any accidental household injury. The defense Woodward's legal team built was unusually well-resourced for a case of this kind, in large part because her legal fees were covered by her former employer, Cultural Care Au Pair, which retained Barry Scheck as lead counsel, an attorney who would later become widely known as a co-founder of the Innocence Project and one of the country's most prominent specialists in challenging forensic evidence. Scheck and the defense team pursued a strategy built around medical and forensic counter-evidence, arguing that Matthew's injuries were not freshly inflicted at the time he became unresponsive, but were instead the product of an older injury, possibly sustained days earlier, that had simply re-bled or worsened under the added strain of his condition that morning, a theory intended to separate Woodward's actions from the timing of his collapse. As part of a deliberate trial strategy, Woodward's attorneys specifically requested that the jury not be given the option of convicting her of the lesser-included offence of manslaughter, betting instead on an all-or-nothing outcome that would either fully exonerate her or, in the defence's apparent calculation, expose the weaknesses of a murder charge they believed prosecutors could not adequately prove. That gamble did not pay off in the way the defense had hoped. The trial, which opened in October of 1997, became an international sensation, drawing intense daily coverage in both the United States and the United Kingdom, where the proceedings carried particular weight, given Woodward's nationality and the unfamiliarity at the time of British audiences with the format of televised American courtroom trials. On October 30th, 1997, the jury returned its verdict, finding Woodward guilty of second-degree murder rather than first-degree murder, a verdict that, under Massachusetts law, carried a mandatory sentence of life in prison, with the possibility of parole only after serving a minimum of 15 years. The judge presiding over the case, Hiller B. Zobel, formally imposed that life sentence at a separate sentencing hearing. In the days immediately following the verdict, an unusual development emerged that would reshape the entire trajectory of the case. Reporting at the time revealed that the jury had been deeply split over the murder charge during deliberations, and according to at least one juror who spoke publicly afterward, none of the 12 jurors actually believed Woodward had set out to murder Matthew, even as they had ultimately settled on a second-degree murder verdict, given the legal options technically available to them once the defence's strategic gamble had removed manslaughter from their list of choices. That revelation set the stage for Woodward's defense team to file a motion asking Judge Zobel to exercise a power available to trial judges in Massachusetts in certain circumstances, the authority to reduce a jury's verdict to a lesser charge if the judge believed the verdict, as returned, would constitute a miscarriage of justice. On November 10, 1997, Judge Zobel granted that motion, issuing a ruling that reduced Woodward's conviction from second-degree murder to involuntary manslaughter. In his written decision, Zobel offered a detailed explanation of his reasoning, writing that the circumstances in which Woodward had acted were characterized by confusion, inexperience, frustration, immaturity, and some degree of anger, but explicitly stated that he did not find evidence of malice in the legal sense that would be required to sustain a conviction for second-degree murder. He went further, stating plainly that he was morally certain that allowing Woodward to remain convicted of second-degree murder on the evidence presented at trial would itself amount to a miscarriage of justice. Alongside the reduced charge, Zobel resentenced Woodward to time served, a total of 279 days already spent in custody since her arrest, and ordered her immediate release. The reduction and release triggered an immediate and furious reaction from Matthew's parents. Deborah Eapen, speaking publicly about the judge's decision, captured the family's anguish in a single pointed statement, telling reporters that Woodward had taken away Matthew and that the judge had taken away justice, a line that crystallized the sense among the Eapen family and many outside observers that the legal system had ultimately failed to hold Woodward fully accountable for what had happened to their son. Prosecutors, sharing at least part of that frustration, filed an appeal seeking to have Woodward's original second-degree murder conviction reinstated, or, failing that, to have her resentenced under harsher terms. A legal challenge that required Woodward to remain inside Massachusetts while the appeal worked its way through the courts, rather than immediately returning home to England. That appeal reached the Massachusetts Supreme Judicial Court, the state's highest court, which issued its ruling on June 16, 1998. In a closely divided 4-3 decision, the court upheld both Judge Zobel's reduction of the conviction to involuntary manslaughter and his sentence of 279 days already served, formally closing the legal process. The court's written ruling was careful to note that its decision did not amount to a declaration of Woodward's innocence, stating explicitly that she stood guilty of causing an infant's violent death, language meant to make clear that the appellate court was upholding a finding of legal responsibility, even as it left the more lenient manslaughter conviction and the already served sentence intact. With the ruling finalised, Woodward was permitted to leave Massachusetts and returned home to England that same month. The legal aftermath did not end cleanly, even after Woodward's return home. Matthew's father filed a civil wrongful death lawsuit against her in the hours following the appellate court's decision, a parallel track of litigation operating under a lower burden of proof than the criminal case had required. Woodward initially failed to respond to that lawsuit after returning to England, a lapse that drew its own wave of criticism, before the matter was eventually resolved through a settlement reached with Matthew's parents. The medical question at the centre of the case never fully settled into public consensus either, even years after the courts had closed the matter. A CBS News programme later aired a segment in which a prominent pathologist who had reviewed Matthew's X-rays, scans, and other medical records at the network's request offered a third theory entirely, suggesting that Matthew might have died from strangulation rather than from the shaking and impact mechanism the prosecution's experts had described at trial. That theory provoked its own backlash, with a group of more than 70 physicians publicly criticising the broadcast as implausible, and revelations later surfaced that one of the doctors involved in advancing the strangulation theory had been compensated by Woodward's own defence team, complicating the credibility of the late-breaking claim. Woodward's attorneys, while expressing interest in any findings that might further support her position, ultimately did not pursue a new trial based on the theory, and the manslaughter conviction has remained the final legal word on the case. What stays in the public record about Louise Woodward is the unusual way the case resolved, not through a clean verdict that satisfied either side, but through a judge's extraordinary intervention that left both Matthew's parents and many outside observers convinced that the punishment had not matched the loss. A 19-year-old hired through a system explicitly built around inexperienced young caregivers, placed alone with an infant for hours at a time, whose actions during one of those ordinary mornings left an 8-month-old boy with injuries severe enough to end his life within days. Louise Woodward served 279 days in custody for the death of Matthew Eapen, and the case that bears her name remains, decades later, a defining example of how differently a single set of facts can be understood, by a jury, by a judge, by a grieving family, and by the wider public watching from outside the courtroom. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. Louise Woodward's case became a referendum on an entire system of inexperienced caregivers placed alone with infants. The next case moves to Maryland, where a live-in nanny named Oluremi Oyinda was caught on camera ending the life of an 8-month-old girl left in her trust. Section 9. Oluremi Oyinda. On the afternoon of October 24, 2016, inside a family home in Glenarden, Maryland, an 8-month-old girl named Anita Salubi sat in her baby walker, bouncing and reaching toward the woman hired to care for her while her parents were away. The nanny, a woman in her early 70s named Oluremi Oyinda, who also went by her maiden name, Oluremi Adeleye, was lying on the couch, napping. Anita, restless and wanting attention, tugged at the older woman's dress and patted her leg, crying in the way babies do when they want to be picked up or fed. That crying eventually woke Oyinda from her nap. What followed, captured in full by an in-home nanny camera the family had installed, would become one of the more disturbing pieces of video evidence ever played in a Maryland courtroom, documenting in real time exactly how a caregiver hired to keep a baby safe instead became the reason that baby never came home. Oluremi Oyinda was a native of Nigeria who, at the time of the incident, was 66 years old, and by the time her case reached trial roughly 2.5 years later, she was 73. considerably older than the typical profile of a hired nanny in the United States. She had been hired as a live-in caregiver by Nakia Porter and Influence Salubi, a Glenarden couple with 3 children, to provide care while the parents worked, an arrangement that placed her, like so many caregivers in this collection, alone with a household's youngest and most vulnerable member for extended stretches of the day, with no other adult present to observe what was happening inside the home. The family, perhaps out of an abundance of caution common among parents who hire live-in help, had installed a home surveillance camera inside the residence, a system that would ultimately prove decisive in establishing exactly what happened to Anita that afternoon. The footage, later played in court during Oyinda Sola's trial, showed the baby in her walker, fussing and reaching for the nanny's attention, while Oyinda Sola rested on the couch. Once awake, Oyinda Sola got up and made an initial attempt to feed Anita normally, an attempt that, according to the charging documents police later filed, did not go well. Rather than continuing to try a calmer or more conventional approach, prosecutors said, Oyinda Sola proceeded to pour a large amount of white liquid directly into the infant's mouth, a description that police charging documents rendered in stark clinical language, but that the video itself showed in far more visceral detail. According to prosecutors and the footage itself, Oyinda Sola removed the nipple from the baby's bottle entirely and began pouring milk straight into Anita's mouth, forcing roughly 8 ounces of liquid down the infant's throat in under 30 seconds. A pace and volume that gave the baby no opportunity to swallow normally or to breathe between gulps. The video showed Anita struggling against what was happening to her, squirming in Oyinda Sola's arms as the milk continued to be poured into her mouth. The struggling did not stop the feeding. Anita eventually fell to the ground, and rather than recognizing this as a sign that something had gone seriously wrong, Oyinda Sola picked the baby back up and attempted to give her a second bottle of milk, repeating essentially the same forceful, rapid pouring motion that had already overwhelmed the baby. Infant once. Police would later note in their charging documents that the child, force-fed this second bottle, began showing visible difficulty breathing and other clear signs of medical distress. It was only after this second attempt that Anita went limp in Oyinda Sola's arms, the unmistakable physical sign that the baby had stopped breathing or had lost consciousness entirely, her body no longer responding the way an alert, healthy infant's body responds. What Oyinda Sola did in the minutes immediately following Anita going limp would become one of the most damning details prosecutors presented at trial. Rather than calling for help right away, the video showed her rocking the unresponsive child for several minutes, wiping her face and making what appeared to be informal efforts to revive her on her own. The kind of improvised, untrained response that wasted critical time an infant in genuine medical distress could not afford to lose. Only after this delay, roughly 20 minutes after Anita had gone limp, did Oyinda Sola finally call the baby's father to tell him that something was wrong. A call that came far later than the situation demanded, and that left Influence Salubi without any real understanding, in that first phone call, of just how dire his daughter's condition already was. Influence Salubi later testified that he had been at work when he received that call, and that he immediately left to get home, calling 911 along the way once he understood the severity of what he was being told. When he arrived at the house, he found his daughter lifeless, her feet already cold to the touch, with milk still streaming from her mouth and nose, a detail that spoke to how much time had already passed since she had stopped breathing, and how far beyond any realistic chance of simple resuscitation the situation had already moved. Anita was rushed to the University of Maryland Prince George's Hospital Center, where she was pronounced dead, the formal medical conclusion to an ordeal that the surveillance footage had already documented in agonizing detail before any doctor ever examined her. In the courtroom, Influence Salubi gave voice to the brutal simplicity of what his family had lost, telling the court directly that he had left home that morning with a live baby and come home to a dead one, a statement he followed by saying plainly that it was not something he could ever forget. Salubi shook visibly with anger and grief as he testified during the trial, according to reporters present in the courtroom, and Nakia Porter, Anita's mother, later spoke about the lasting damage the loss had done to the rest of the family, including Anita's 2 older siblings, who had been in the room when their baby sister was killed. Porter said her 2 surviving children continued to ask, long after their sister's death, where she had gone and when she was coming home, sometimes offering their own innocent explanation by asking whether she was simply in heaven, a question Porter said she and her husband were left to answer again and again. Oyinda Sola was arrested in the days following Anita's death and held on a $1 million bond while prosecutors built their case, a process made significantly more straightforward than in many of the other cases covered in this format, because the central act, the forced and rapid pouring of milk into the struggling infant's mouth, had been captured on video from beginning to end, leaving little room for the kind of competing medical theories or circumstantial reconstruction that so often complicate caregiver homicide cases. She was charged with second-degree murder, first-degree child abuse resulting in death, and second-degree child abuse, charges that together reflected both the fatal outcome and the underlying abusive conduct that had caused it. Rather than face a jury, Oyinda Sola, charged under her married name but identified in court records under both names, chose to have her case decided through a bench trial, a proceeding in which a single judge weighs the evidence and renders a verdict, rather than 12 jurors. The case was heard in Prince George's County Circuit Court before Judge Karen H. Mason, and the trial stretched across roughly a week of testimony. During that week, prosecutors built their case around the surveillance footage, walking the court through the sequence frame by frame, while also presenting testimony from the emergency responders who had treated Anita on scene. Oyinda Sola's defense pursued an unusual and culturally specific argument, telling the court that there had been no malicious intent behind her actions, and that in her native Nigeria, it was customary to feed children in a more forceful, hands-on manner to ensure they did not go hungry, a practice her attorney described in court as cup feeding. Her defense called several of her relatives to the stand, who described this cultural feeding custom and attempted to frame what the video showed as a misguided but culturally rooted parenting technique rather than an act of abuse. Oyinda Sola testified in her own defense, telling the court directly that she had not intended to hurt the child and that she had only been trying to make sure Anita did not go hungry. That account ran into a serious credibility problem once prosecutors introduced her earlier statements to homicide detectives. According to testimony presented at trial, Oyinda Sola had initially denied unscrewing the cap of the bottle to feed Anita when detectives first questioned her, only changing her account and admitting to removing the cap after a detective informed her that video footage of the incident existed. Judge Mason, in announcing her verdict, specifically cited this shifting story as a critical factor in her ruling, stating that the inconsistency between Oyinda Sola's initial denial and her later admission, once she learned she had been recorded, demonstrated what the judge described as a consciousness of guilt. The defense had also argued that much of the milk involved had simply run down Oyinda Sola's own dress and down the front of the baby's shirt, rather than being forced into her airway. But Judge Mason rejected that characterization as well, pointing to testimony from the emergency responders who treated Anita, who told the court that milk had come out of the baby's nose and mouth with each of the 20 chest compressions they performed while attempting to revive her, physical evidence the judge found inconsistent with the defense's theory that the milk had mostly missed its target. On February 11, 2019, Judge Mason found Oyinda Sola guilty on all 3 counts: second-degree murder, first-degree child abuse resulting in death, and second-degree child abuse. In delivering her ruling, the judge went further than simply finding the elements of each charge satisfied, describing Oyinda Sola's actions during the feeding as cruel and inhumane, a characterization that left little ambiguity about how the court viewed the conduct the video had captured. Following the conviction, Oyinda Sola faced a maximum possible sentence of up to 70 years in prison under Maryland law, given the combination of charges on which she had been found guilty. At her sentencing hearing on May 3, 2019, Oyinda Sola broke down in court, falling to her knees at one point and speaking through an interpreter as she addressed Anita's family directly. "Please forgive me," she said. adding that she had not meant to kill the child, an apology that came after she had already been found guilty following a trial in which her own shifting statements to police had been used as direct evidence against her. Prince George's County State's Attorney, Aisha Braveboy, spoke about what had been taken from Anita specifically, noting that the little girl would have turned 3 years old that year had she lived, and saying that she had deserved the chance to grow up and to have a life in which she could pursue her own dreams. A statement that placed the weight of the case squarely on the years and possibilities that had been cut short, rather than solely on the legal mechanics of the conviction. The court sentenced Oyinda Sola to 40 years in prison, with all but 15 years of that term suspended, meaning she would serve 15 years in active custody, followed by an additional period in which the remainder of the sentence would remain held over her, contingent on her compliance with the terms set by the court. Alongside the prison term, she was ordered to serve 5 years of supervised probation following her eventual release, extending the period during which she would remain under direct court oversight well beyond the active portion of her incarceration. Given her age at the time of sentencing, 73 years old, the 15-year active sentence carried particular weight, representing a substantial portion of whatever years she had left, regardless of the suspended balance attached to the full 40-year term. What stays in the public record about Oluremi Oyinda Sola is the unusual completeness of the evidence against her, a case where almost nothing was left to inference or competing expert testimony, because a small camera mounted inside a family's own living room recorded the entire sequence, from a fussing baby in a walker to a lifeless infant being handed off to paramedics, and even captured the choices Oyinda Sola made in the critical minutes afterward, when she chose to rock and wipe the unresponsive child rather than immediately call for outside help. A caregiver entrusted with a household's 3 children, including its youngest and most physically helpless member, who responded to that infant's ordinary, age-appropriate fussing with a level of force that the child's body could not survive, then offered an explanation rooted in cultural feeding custom that the trial judge ultimately found undermined by the nanny's own shifting account to detectives once she learned the moment had been recorded. Oluremi Oyinda Sola is currently serving her sentence in a Maryland correctional facility, and the video that convicted her remains, in the words used by the family who hired her to keep their daughter safe, the unforgettable record of leaving home with a living child and returning to one who was already gone. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. Oluremi Oyinda Sola was caught entirely on camera, leaving no question about what happened to the baby left in her care. The final case moves to Michigan, where a caregiver named Colleen Kelly O'Connor watched an elderly woman wander into a blizzard not once, but twice, and did nothing to stop her either time. Section 10. Colleen Kelly O'Connor. In the early hours of December 23, 2022, 2 days before Christmas, a powerful winter storm settled over central Michigan, bringing single-digit temperatures, sub-zero wind chill, and the kind of blowing and drifting snow that turns a short walk outside into a genuine survival risk within minutes. Inside Vista Springs Imperial Park at Timber Ridge Village, an assisted living facility on Park Lake Road in Bath Township, Clinton County, an 82-year-old resident named Lois Catherine Carey was awake during those early morning hours, and at some point amid the storm, she made her way toward the building's exit, dressed in nothing close to what the conditions outside required. A caregiver on duty that night, 58-year-old Colleen Kelly O'Connor, saw her attempt to go outside. Rather than this single moment ending the danger, it would repeat itself a second time before the night was through, and by morning, a snowplow driver clearing the facility's parking lot would find Lois Carey's body, partially buried in drifted snow, the final outcome of a night in which the person responsible for watching over her had, according to prosecutors, twice had the chance to stop her and twice failed to act. Lois Catherine Carey was 82 years old at the time of her death, a resident of Vista Springs Imperial Park at Timber Ridge, an assisted living facility built specifically for older adults who need a level of daily supervision and support beyond what they can manage entirely on their own, but who do not require the more intensive medical care of a full nursing home. Facilities of this kind occupy a particular space in elder care, often housing residents who retain some independence and mobility, but who may also experience the kinds of cognitive changes, confusion, or wandering behaviour that staff are specifically trained to anticipate and to manage, particularly during overnight hours when residents are more likely to be unsupervised by family, and when fewer staff members are typically on duty across the facility. Colleen Kelly O'Connor of East Lansing, Michigan, was employed as a caregiver at Vista Springs Imperial Park at the time of the incident, working in a role that placed her directly responsible for monitoring residents like Lois Carey during overnight shifts, precisely the hours when a resident attempting to leave the building unsupervised would be most likely to go unnoticed by anyone other than the staff member on duty. The structure of assisted living work in facilities like this one depends heavily on a relatively small number of staff members maintaining awareness of a building full of residents who may need anything from routine check-ins to direct physical intervention. An arrangement that gives individual caregivers like O'Connor substantial discretion over how closely they monitor any one resident at any given moment. Discretion that, according to the case prosecutors built, O'Connor failed to exercise on the night in question. According to evidence later presented by the Michigan Attorney General's office, during the very early morning hours of December 23, 2022, O'Connor personally observed Lois Carey attempt to go outside without appropriate winter attire, into a blizzard already producing single-digit temperatures, sub-zero wind chill, and blowing and drifting snow severe enough that the broader Lansing region was under an active winter storm warning, with blizzard conditions that would persist for more than 2 days. This was not a single missed moment buried among countless ordinary overnight observations. According to the Attorney General's office, O'Connor witnessed this same attempt by Carey to leave the building improperly dressed, not once, but twice that night, meaning that whatever attention or intervention might reasonably have been expected after the first occurrence, the second sighting represented an even clearer opportunity to prevent what eventually happened. Prosecutors argued that as a caregiver specifically tasked with the responsibility of protecting a vulnerable adult resident, O'Connor recklessly failed to act on either occasion to prevent Carey from going outdoors into the storm, a failure that the state would ultimately argue led directly to her death. What happened during the gap between O'Connor's second observation of Carey's attempt to leave and the moment Carey was finally found remains, in important respects, unknown, a detail investigators and prosecutors were candid about throughout the case. It is unknown precisely how long Lois Carey was outside in the blizzard conditions before anyone located her, a gap in the timeline that reflects just how unsupervised that stretch of the night had become once she had actually made it outside the building. What is documented clearly is the discovery itself. Around 7 o'clock the following morning, a snowplow driver working to clear the facility's parking lot during the ongoing storm came across Lois Carey lying outside, partially covered by a layer of drifted snow that had accumulated around her in the hours since she had gone out into the storm. She was transported by ambulance to a nearby hospital, but the exposure to those sub-zero conditions had already done damage beyond what emergency medical care could reverse. She died at the hospital a short time after arrival, with hypothermia formally identified as the cause of death. The investigation into Lois Carey's death involved close cooperation between local and state authorities, with the Bath Township Police Department working alongside the Michigan Attorney General's office, whose healthcare fraud division handles cases involving vulnerable adults in licensed care settings as part of its broader mandate, a unit that receives the majority of its funding through a federal grant specifically tied to Medicaid fraud and elder abuse enforcement. That collaborative investigation eventually led to a charge against O'Connor of vulnerable adult abuse in the second degree, a felony under Michigan law carrying a potential sentence of up to 4 years in prison, a charge specifically tailored to situations involving the reckless failure of a caregiver to protect someone in their care, rather than a more severe homicide charge that would have required prosecutors to prove a higher level of intent or direct causation. O'Connor was formally bound over for trial following a preliminary hearing in January of 2024, more than a year after Lois Carey's death, reflecting the time it took investigators and prosecutors to assemble the surveillance evidence, facility records, and witness accounts necessary to bring the case forward. Her defense attorney, David B. Carter Jr., pushed back publicly against the characterization of the case even before trial began, describing the incident as a tragic accident rather than an intentional or reckless act on his client's part. Carter expressed sympathy for Lois Carey's family while maintaining that his client had not committed any wrongdoing, telling reporters that he believed O'Connor would ultimately be found innocent once the full circumstances of that night were presented in court. A defense strategy aimed at reframing the case as an unavoidable tragedy rather than the product of a caregiver's specific failure to act. The trial took place in Clinton County and ran approximately 2.5 days, a relatively compact proceeding given the gravity of the underlying loss, built substantially around the same surveillance evidence that had originally helped investigators establish the timeline of that December night. The Attorney General's office presented evidence directly to the jury, demonstrating the 2 separate occasions on which O'Connor had observed Lois Carey attempting to leave the building without proper winter clothing amid the blizzard, framing the case not as a single missed glance, but as a documented, repeated failure to intervene once the danger had already revealed itself clearly the first time. The defense, consistent with its pre-trial framing, argued that O'Connor's actions, or lack of action, did not rise to the level of reckless conduct the charge required, suggesting instead that the tragedy reflected the inherent unpredictability of caring for residents who could attempt to wander or leave a facility despite a caregiver's reasonable efforts. The jury was not persuaded by that defense. On June 7, 2024, a Clinton County jury convicted Colleen Kelly O'Connor of 1 count of vulnerable adult abuse in the 2nd degree, finding that her failure to act after twice witnessing Carey's attempts to go outside into dangerous blizzard conditions met the legal standard of recklessness required under the statute. Michigan Attorney General Dana Nessel spoke directly to the broader stakes of the case in a statement issued after the verdict, saying that the conviction did not undo the tragic loss of life, but that she hoped it would serve as a reminder of the immense responsibility caregivers carry, language that echoed across nearly every case examined in this collection. The gap between the responsibility a caregiving role demands and the consequences that follow when that responsibility goes unmet. O'Connor's sentencing hearing took place on September 16, 2024, before Judge Corey E. Barkman of the 29th Circuit Court in Clinton County. Rather than imposing the maximum 4-year prison term available under the felony charge, Judge Barkman sentenced O'Connor to 2 years of probation, with the first 6 months of that probationary period to be served in jail rather than in a state prison, a structure that placed the bulk of her punishment in the form of extended supervision rather than lengthy incarceration. The court also ordered O'Connor to pay $1,115 in restitution to Lois Carey's daughter, a relatively modest financial penalty set against the scale of the loss the family had experienced, reflecting the limited scope of what a restitution order in a case like this is typically structured to address. Attorney General Nessel, commenting again at the time of sentencing, returned to the same theme she had emphasized after the verdict, stating that caregivers bear immense responsibility, one that is tragically neglected at times, and that the devastating consequences of this particular incident underscored the importance of vigilance and compassion in fulfilling that obligation. The case drew attention from advocacy groups and legal organizations focused on nursing home and assisted living oversight in Michigan, several of which pointed to the broader pattern the case represented, the particular danger that winter weather and inadequate staffing levels can pose for residents prone to wandering or elopement from assisted living facilities, a risk that elder care advocates have increasingly highlighted as facilities across the country manage growing numbers of residents with limited overnight staffing. What stays in the public record about Colleen Kelly O'Connor is not a story of deliberate poisoning or calculated violence, the kind of active, hands-on killing that defines so many of the other cases in this collection. But something quieter, and in some ways more unsettling, precisely because of that quietness. A caregiver who saw the danger forming twice, and, according to the jury that heard her case, chose inaction both times. Lois Catherine Carey had lived to 82 years old, a resident of a facility built specifically to support people like her through the vulnerabilities that come with aging. And she died alone in a parking lot during a blizzard, partially buried in snow, found not by the staff paid to watch over her, but by a snowplow driver clearing the lot the next morning. Colleen Kelly O'Connor is currently serving the terms of her probation, including the jail portion of her sentence, the legal consequence of a recklessness measured not in a single fatal injection or a single violent act, but in 2 missed chances to simply stop an 82-year-old woman from walking out into a storm that would kill her. If you enjoyed this breakdown, make sure to subscribe. Thanks for watching, and I'll see you in the next video.